Hi, my name is Laura Clark and I'll be discussing the key facts and findings in the case of Bleyer and Google, a New South Wales Supreme Court case of 2014. This case relates to a claim of defamation by Mr. Bleyer, the plaintiff, against Google, the defendant, for the publication of material accessed by 3 individuals in Australia as a result of a Google search which allegedly produced defamatory material about Mr. Bleyer. By way of a brief background, the material in question was downloaded initially by 2 individuals in Australia in December 2012. On 1 March 2013, Mr. Bleyer's solicitors wrote to Google to put them on notice as to the defamatory material. Shortly thereafter, the web page in question was again accessed via a Google search in April 2016 by a 3rd individual in Australia. The plaintiff's key claim against Google sought to invoke the processes of the court to vindicate the alleged harm to his reputation as a result of the publication of material to 3 people who undertook a Google search, finding the web page and defamatory material in question. On the other hand, Google's claim was that the proceedings should be stayed or summarily dismissed on the grounds that the claim does not disclose a real or substantial tort and is an abuse of process. The fundamental question before Justice McCallum was whether the court has the authority to decline to determine a civil claim on the grounds of proportionality between the cost of doing so and the interests at stake. Justice McCallum discussed the case of Grisonic and Sutor in dealing with the issue of proportionality. His Honour also considered the relevance of Jamil and Dow Jones & Co. Incorporated, a case of 2005. In addition to determining the issue of proportionality, Justice McCallum also considered other issues raised by the application, including whether Google is liable for publications on its search engine. In arguing this issue, Google relied on 2 English decisions, which both held that Google could not be regarded as a publisher for the purposes of defamation law, because there is no human input into the search process. The evidence before Justice McCallum therefore strongly established that there is no human input into the application of the Google search engine, and further chose to adopt the English line of authority in the sense that, at least prior to notification, Google cannot be liable as a publisher of the results produced by its search engine. On this basis, Google can be found liable for just one publication of the defamatory material with respect to the 3rd person who accessed it. Another argument raised by Google was a claim under Section 32 of the Defamation Act, being the defence of innocent dissemination, which is, in effect, a denial of publication with respect to the first 2 publications. Further, Google also raised the argument as to the relevant Australian law not being enforceable in the United States, relying on the case of New York Times Co. and Sullivan. This is with respect to Google being a US-based company. Conclusively, Justice McCallum held that any judgment obtained by Mr. Bleyer would be unenforceable on the grounds of proportionality. He further stated that even if Google was found liable as to the first 2 instances of publication, Google would not be found liable as a publisher. This only leaves 1 instance of publication as to the 3rd individual, which Mr. Bleyer would fail in a claim against Google in the view of the proportionality rule. Ultimately, Justice McCallum was persuaded that the resources of the court and the parties that will be expended to determine the claim are out of proportion. For those reasons, His Honour ordered that the proceedings be permanently stayed. Thank you.